Hello, my name's Gary McIndoe from Latitude Law Solicitors in Manchester and Liverpool. I just wanted to pick up on the government's announcement yesterday about its new immigration route for British nationals overseas who are going to be looking at their options following China's introduction of new security laws in the territory from the beginning of July 2020. My first proper job at 18, when I dropped out of university for the first time, was at the Home Office's Immigration and Nationality Department, as it was then known. I got through the executive officer recruitment process and was offered a position at Luna House. So I duly moved to Croydon from my Manchester home, and that was in March 1985. After training, while most of the intake were allocated to B1, General Casework Division, I was sent to B2, Policy Division. To this day, I've got no idea why a callow youth like me was considered a good fit for that job. My role mainly involved casework, but in respect of holders of British passports who weren't quite British enough. So British overseas citizens, British dependent territory citizens, British protected persons, and British subjects. During my 3-year tenure, I was asked by a chap called Robin Macefield, who was a senior official in B2 Division, to conduct some research into the particular issues facing BDTCs from Hong Kong, in light of the joint Sino-British declaration that had been signed on the 19th of December 1984. Robin, a quick search reveals, has enjoyed a long and illustrious civil service career. Unlike me, I went on to leave at 21 and go and work and live in a kibbutz in Israel. The point of all this is that 10 years after I left the civil service in 1997, Hong Kong was returned to the UK by China. We've just seen the 23rd anniversary of the handover, and with it confirmation from the People's Republic that it has implemented harsh new security laws over the territory. I prefer to believe that my 1980s research formed no part whatsoever of the dog's dinner of citizenship and immigration laws that the British government went on to enact in respect of Hong Kong and its residents. The basic arrangement for BDTCs from Hong Kong was that their citizenship would cease to be replaced by British national overseas status. So if we look at the Hong Kong Act 1985, paragraph 2.1 of the schedule to that act provides that persons who are BDTCs by virtue of any such connection with Hong Kong may, before 31st December 1997, acquire a new form of British nationality, the holders of which shall be known as British nationals, brackets overseas, close brackets. People didn't become BNOs automatically. They had to apply for it, apply for that status within specified time limits. And the status cannot be passed down through generations. Thus, there are no BNOs born after the handover of Hong Kong on 30th June 1997, meaning the youngest BNO, who had until 31st December that year to apply, has just celebrated their 23rd birthday. I'll return to this issue later. Is BNO status inferior to other categories of British nationality? Well, most definitely. The UK has long struggled with these different forms of nationality, which are a consequence of our history. They were created in order to ensure large numbers of people with connections to former colonial possessions couldn't freely enter and reside in the UK. While the government went on to ameliorate things for holders of certain forms of British nationality who held no other citizenship, this includes some British overseas citizens, for example, it's never done the same for BNOs, who under Chinese law were also entitled to Chinese citizenship. So the British government hasn't acted until now. So in Parliament yesterday, the 1st of July, in direct response to China's new security laws, Foreign Secretary Dominic Raab announced that the government intends to create a new immigration path to settlement in the UK for BNOs. He does mention citizenship in the announcement, but only in the context, we think, of future registration entitlements to full British citizenship upon completion of 5 years residence in the UK and possibly another 12 months residence here after that. Others have commented elsewhere that the visa on offer could well mirror the UK ancestry route that has been a feature of our immigration rules for years. This permits Commonwealth citizens with a UK-born grandparent to require a 5-year work visa, and that leads to settlement. Administratively, it seems likely that the new scheme for BNOs will mirror this. Importantly, Home Secretary Priti Patel added that the new immigration route would apply to BNOs and their families. So this gives hope perhaps to some of the younger Hong Kong residents, the younger protesters, I guess, who were involved in the opposition to the security crackdown in Hong Kong, who were not born before June 1997 and who hold Hong Kong SAR passports, hope that they too will be able to live and ultimately work in the UK. Now, family members in domestic UK immigration law are invariably limited to the spouse, civil or long-term partner, and children under 18. Potentially left out, therefore, are family members of BNOs, unable to become BNOs themselves, remember, aged between 18 and 23. This is precisely the age group really who are most likely to be students and most likely to be on the streets demonstrating. It'll be interesting to see if rules are introduced to take account of this group of individuals, this young group of Hong Kong residents who probably stands to benefit most from these new British immigration provisions.